And I'm going to share my screen now.
Well, great. Thank you, Danielle, and good morning, everyone. Malvina and I are happy to present today. Just real briefly about us, Goldman & Partners Immigration is a law firm. We're based out of Boston and Cambridge, Massachusetts, and San Mateo, California. We practice exclusively immigration law, and almost all of that is representing foreign nationals and who are obtaining either a work immigration status or a green card through their employment or through their expertise. And we're going to today be discussing how the green card process works. What does it mean to be EB-1 or EB-2 or different categories? And what does it mean to have your priority date be current, which means really your place in the queue or in the backlog has come to the front of the line. And we also want to talk about the different EB-1 categories and strategies when you're planning and thinking about applying for an EB-1 green card. And then we definitely want to take any questions that you have at the end. So to start off with, I want to jump in and just explain a little bit about the green card system in the United States. We have a limited number of green cards every fiscal year. First of all, the fiscal year in the United States runs from October 1st through September 30th. So we are approximately halfway through the federal fiscal year right now. And each year, there's a limited number of green cards that are given out. Some are reserved for employment-based reasons and some for family-based reasons. And under the employment-based green card categories, there's only 140,000 green cards available every year. That sounds like a lot, but the fact is the demand well exceeds the number of green cards available. The employment-based green card categories are segregated by number. EB means employment-based, and we have categories for EB-1. Those are the green cards that are most prized by the United States. They're reserved for the people we want the most. These are for people who are extraordinary in their fields or outstanding professors and researchers or multinational executives and managers. EB-2 are the group we want the second most. These are foreign nationals who have either an advanced degree or they can prove that they have exceptional ability. EB-3 is reserved for those foreign nationals who are being sponsored by an employer but don't fall into EB-1 or EB-2. So basically it's everyone else. It might be people with only a bachelor's degree or no bachelor's degree, or jobs that simply don't require any degree at all. EB-4 is reserved for special classifications. This includes a whole host of different categories. Maybe the most common one are for ministers and religious workers. But it also includes individuals who may have come without a visa at all, juveniles who have a special path to green card. It also includes women or men who have been abused in a violent relationship. So those people would fit into an EB-4 green card. And then EB-5 is for people who are making a very large investment in the US economy and creating at least 10 jobs. The amount of the investment for EB-5 currently is $1,800,000. Create 10 jobs and you get a green card. The amount is reduced to $900,000 if you can create the 10 jobs in an area of high unemployment or a rural area. But Malvina and I want to today focus on EB-1, which are the green cards for extraordinary ability, outstanding researchers, and professors, and also multinational executives and managers. So as I said, only 140,000 employment-based green cards every fiscal year. 40,400, sorry about that, 40,400 are reserved for the first three preferences, EB-1, EB-2, and EB-3, and they go quickly. One additional number of green cards are available because any green cards that are unused by EB2 or EB3 will flow over to EB1. And there do tend to be some unused green cards every year, which I don't understand because there's way more people applying in EB2 and EB3 than there are green cards available. Yet somehow the numbers do, there are extra green cards that are not used that do trickle down to the EB1 category. And I suppose they could also trickle down from all of the other EB categories. So any of the 140,000 that are not used will be made available for the EB1 category the following fiscal year. So it does turn out that more than 40,400 are given out in the first three categories due to the numbers that are unused in other categories. I do want to point out that your preference category depends on, okay, let me back up for 1 second. Another restriction other than the total of 140,000 green cards available every year is a cap of 7% for each individual country. So no country is allowed to use up more than 7% of the available green cards each fiscal year. For most countries around the world, that's fine because they don't even come close to using up 7%. But there are 4 countries that regularly exceed the 7%, and that is India, China, Mexico, and the Philippines. And sometimes even Vietnam and a few other countries sometimes exceed the 7%. And that can cause an extraordinarily long backlog. Malvina is going to tell you more about the backlogs and how you keep track of them and how you would know about a backlog. But I want to say one more important thing. Because no country can use up more than 7% of the green cards, it's important to know what country you're being counted against. And the way the government does it is they take your country of birth, not necessarily the country you are a citizen of today. So it's rather common for many people around the world from either India or China to be citizens of another country, such as Canada. But when you go to apply for the green card, they're using your country of birth, not where you are necessarily a citizen of today. Another maybe lesser known fact is you are allowed to take on the nationality of your spouse and where your spouse was born. So if you're born in India and you have an extraordinarily long backlog, but you're married to a person from Australia, you can take on the nationality of Australia, which has no backlog, and that is a huge benefit. So I'm going to switch over to Malvina and let her discuss more about the limits and how you keep track.
Hi, everybody. And also just to touch on one other situation where we have seen a few times is we have seen citizens of India or China, for example, who actually were born in another country. Their parents might have been living abroad and they lived abroad at that time and may not have been, able to take on the citizenship of the country where they were born, but they were still born in that country. So we've actually been able to get green cards for citizens of India and China who might have been born, say, in one of the countries in Africa or Asia, and we're not subject to any backlog. So that's something to keep in mind too, is just, again, where you were born. So how do you keep track of where you are in this backlog? There is something called the Visa Bulletin that is issued by the U.S. State Department every month. And this Visa Bulletin is, it has several charts on it that show where the backlogs are according to one's priority date. Your priority date is established in the EB-1 category when the I-140 immigrant visa petition is filed. And so it's very important to know when, if you already have an I-140 petition that is filed and pending, or if someone is going to be filing an I-140 for you, it matters when the I-140 petition is filed, not when it's approved, when it's filed. The date of filing establishes your priority date. And that's a very important date to know, because when you look at the Visa Bulletin that is issued by the State Department, there will be charts that show not only the preference categories, but the countries that you were born in. And the charts in the Visa Bulletin will show what date the State Department says is current or not. So the State Department issues this Visa Bulletin on a monthly basis. It's usually issued around the 15th or 18th of the month. You can access it electronically on the State Department's website. And it usually comes out the month before, and the charts that have the dates are effective for the following month. So for example, the April Visa Bulletin was issued around the middle of March, but the dates on those charts do not become effective until the following month. So those of you who may have a pending I-140 or an approved I-140, you might already be familiar with the Visa Bulletin and what this means, so that you can track where you are and whether your priority date is current or has a backlog. So in the Visa Bulletin, there are generally a section of charts for family-based cases and then another section for employment-based cases. And the reason why there are two charts is because several years ago, the State Department they had always had what's called a general chart that shows you what dates they were working on for which priority dates were current and which had backlogs. They began introducing a second chart because the second chart is to let you know whether you can file your adjustment of status application for permanent residence, or whether your priority or your immigrant visa petition abroad. And that chart is really governed by what USCIS, or U.S. Citizenship and Immigration Services, says when people can file. So the U.S. Citizenship and Immigration Services is under Department of Homeland Security. They're in the United States. The State Department obviously is another agency separate from Department of Homeland Security. The embassies and consulates fall under the Department of State, but they all follow the same immigration laws. And the two agencies work together to determine how many immigrant visas have been used in a particular fiscal year and how many are left available. So the State Department gets that information from USCIS. USCIS shares with the State Department how many people in the United States might have filed permanent residence applications, so that when the State Department issues its Visa Bulletin every month, they know whether there is a backlog and whether there is not a backlog. If you look on the State Department Visa Bulletin, you'll see in the charts, there might be, for example, a letter C under your preference category for EB-1. And if you are in the category of all world countries, or whether you're in China or India or one of the other categories, if you see the letter C, that means current. For that month, there is no backlog. If you see a date in that category for your row of EB-1 and your column, depending on what country you were born in, if you see a date, that means those are the priority dates where if your priority date is before that date, you are current and you can file your application for permanent residence. If your priority date is after the date on the Visa Bulletin, you still have to wait. You cannot file your permanent residence application or go forward with your immigrant visa petition. When the State Department comes out with their Visa Bulletin roughly around the middle of the month, we still have to wait a few days later for USCIS to announce on its own website which chart we can go by in the Visa Bulletin. So even if the Visa Bulletin comes out in the middle of that month, and for the following month it looks like there's a movement in the priority dates, the movement goes forward, or there's no wait, we still can't file anything in terms of permanent residence yet. We still have to wait a few days later, generally 3 to 5 days later, for USCIS to say which chart we can use. USCIS will either say you can use the first chart, which is the final action dates chart, or USCIS will say you have to use the second chart, which is dates for filing chart. And that really makes a difference, because even if your priority date looks like it's current in the first chart, if USCIS says you can't use that and you must use the second one, then you have to use the second one. And sometimes those dates are different. Sometimes the dates for filing chart is current and you can file your application for permanent residence, and sometimes it says it's not. And so it's very important to know what your priority date is, where it is on the visa bulletin, and which chart USCIS says that you can use in any given month. And of course, this is important for the month of April, because for the month of April, both charts for the first preference category for China and India are current, both on the final action dates chart and the dates for filing chart, which means that for the month of April, those who have not yet filed a permanent residence application, if you're in the United States, can file it during the month of April. Those who may be abroad and are waiting for an immigrant visa to be approved, their process can go forward. So it's really monumental actually for the month of April, because even for the first preference category being the top preferred category for nationals of China and India, there is generally several months to wait. It's very rarely current, but it is current for April in both charts, and that's why it was important for us to get this information out and answer any questions that people may have.
I want to take everyone through a scenario just to put to make a clearer picture of what Malvina was just talking about. If someone has not filed yet for a green card or not for an EB-1 green card, here would be the process. It's a two-step process. The first is filing an immigrant visa petition as an alien of extraordinary ability. That would be an EB-1A petition. And that the priority date that Malvina was discussing, that does not need to be current to file the first part of the green card process. It's known as the immigrant visa petition, or the form number I-140. A lot of people call it the I-140. And that's the hard part. That's proving that you're an alien of extraordinary ability, or that you're an outstanding researcher or professor, or that you're a multinational manager or executive. Those are the three ways you could file an EB-1 immigrant visa petition. The second phase of the process is called adjustment of status, or the final green card application. And it's also known as the form I-485. So what we're talking about is the fact that in April, EB-1 will be current for every country, which means everybody can file both the first part and the second part. Normally, well, always you have to wait until the priority date is current, or they announce that they will let you file early, but you need the permission of the government to file the second part. But now everybody's current and you can file both the first part and the second part at the same time. It's really quite huge. And as we'll talk about in the future, one of the main reasons why it's huge is that it permits the ability of a spouse to get a work authorization card now, as opposed to waiting for years. So we're going to come to that more on that later, but I want to take you through a little more detail of the three categories that fall into the EB-1 green card, starting with EB-1A, aliens of extraordinary ability. This category is reserved only for those foreign nationals who have accomplished two things. One, they have risen to be among the few at the top of the field of endeavor, either nationally or internationally. And two, they have received sustained acclaim. Let's talk about that first, sustained acclaim. That means that the evidence must show that you have received accolades and notoriety, and your evidence extends over a period of time. it didn't all happen in a very short 15 minutes of fame or a very short 1 or 2 years, but rather it was sustained over a period of time. And to prove that you've risen to be among the very top in your field of endeavor, nationally or internationally, the good news is some people find it much easier to prove that they've risen to be among the top of their field only in their home country. They're really not well known outside the country, and they really don't have much evidence showing that they've accomplished much outside of their country. That's okay, because the law says it only has to be nationally or internationally. Secondly, it is to prove that you're at the top in your field of endeavor. There's strategic ways to narrow your field of endeavor, which helps us prove that you've, more likely than not, that you've reached the top. So a good example would be a chemist. There's chemists, which is really quite broad and may be rather difficult to prove that you are among the very top chemists out there. But then there's chemical engineers or biochemists focused on a subdivision of biochemistry. A field of endeavor can be any field which is taught at a university in the United States. So we have found some very narrow fields and proven that they are a field of endeavor by showing proof that there is a university in the United States that offers a course focusing on that particular field of endeavor, and that made it much easier to prove that our clients had risen to the very top of that field. As a starting place for EB-1A, the US CIS lists 10 criteria, and the regulations state if you can prove with evidence that you meet at least 3 of the 10 criteria, you meet the first round of analysis. So you've got to prove you meet 3 out of 10. The 10 criteria range from winning awards and prizes for excellence in the field to having media publications that are truly about you, playing a critical role for an organization of distinguished reputation, having been chosen to be a judge or referee or reviewer of the work of other professionals. If you can meet any 3 of these 10 criteria, and the 10 criteria are all over our website, and all you have to do is Google EB-1 criteria and you'll come to excellent summaries of all 10 criteria. But the point I want to make is if you meet 3 out of 10, that just means that you can move into the second analysis, which is called the merits analysis. And this is where you must prove that when one looks at the totality of all of the evidence together, it is more likely than not that you are one of the few that have risen to the top of your field of endeavor, nationally or internationally, and that you have sustained a claim. So first you have to prove you meet 3 out of the 10, and then you move on to the merits analysis. I want to bring up this distinction between part 1 and part 2 because there's a trend at the Immigration Service to agree that you meet 3 out of the 10 criteria, but then deny a green card because they say that it's very subjective, but still they just feel that you didn't quite prove that the totality of the evidence indicates that you are one of the very top in your field. So what we do is when we're talking to a potential client, we work pretty hard right from the beginning to make sure that not only do we have strong evidence that you meet 3 out of the 10, but that you also are going to be able to get through the second round of analysis, the merits analysis. EB-1B is for outstanding professors and researchers. This is someone who is a professor, yes, but let's just talk about researchers. The cool thing about this category is it does permit all sorts of researchers. It doesn't necessarily have to be a typical scientific researcher. It can be an economics researcher, a medical researcher. It could be a lawyer who does legal research. It can be a business analyst who all day long is analyzing businesses. There's a few big differences though between the EB-1A, extraordinary ability, and the EB-1B, outstanding professor and researcher. The biggest difference is EB-1B requires an employer to sponsor you, where EB-1A, you are allowed to sponsor yourself. And for EB-1B, for outstanding professors and researchers, it needs to be an academic institution that sponsors you, or it could be any private company, but the private company must prove that it has at least 3 full-time researchers other than you, and that it has some renown or acclaim in its own right as an organization. So what they don't permit is for a startup company that no one's ever heard of and no one's ever known about, that might have 3 full-time researchers. It doesn't permit that kind of an organization to sponsor you for an outstanding professor or research petition. And the outstanding researcher also requires you, the foreign national, to prove that you have at least 3 years of experience as a researcher. You are allowed to use research experience gained in pursuing an academic degree, but if you're going to use time spent pursuing the degree, you have an extra burden of proving that some of the evidence proving that you are outstanding took place during the time, or was acquired during the time that you were pursuing the degree. It's true for almost everybody. For example, one of the requirements is, have you published scholarly articles? Most people can prove that they published scholarly articles during the time period they were pursuing the degree, and that would take care of that problem. The last EB-1A category is for multinational managers and executives. And this requires a company to sponsor you. You can have equity in the company. You could even own the company. That's fine. You must prove that you worked for the multinational company. So what is a multinational company? It is where there is an entity outside the US and an entity inside the US, and they are related to each other in one of a few different qualifying ways. It could be that one entity owns a majority of the other. It could be the foreign company owns a majority of the US entity, or the other way around. Or it could be that both entities are brother and sister entities, meaning that they ultimately are owned by the same organization or the same group of people. That's a qualifying EB-1C relationship. The next requirement would be that you, the foreign national, you must have worked for at least 1 full year outside the US for one entity as an executive or manager. And you must prove that you worked 1 year outside the US out of the prior 3 years, or out of a time period just in the 3 years before you entered the US in another category. And you also need to prove that you are in the US or coming to the US to fulfill an executive or managerial duty. One of the big differences between an L1A and the EB-1C green card is the requirement that the US entity must be open and doing commercial business for at least a year before you could apply for the green card. Which is why most people who do qualify for this come first as an L1A, and then after a year they reassess and think, do I have enough to get through the green card? And if they want the green card, that's a good time to start. But I will say right now, we are working on an EB-1C, multinational manager green card, for a person who's never ever been to the US, but fully qualified because the US entity, which is part of the multinational, has been open for more than a year doing business. And he's actually didn't really want to come for another year. He's very busy in China doing what he's doing. He was trying to plan ahead, and when I mentioned he could actually apply for the green card now, that's what he's doing. And if the green card isn't approved, when he wants to come, he'll get an L1 at that time. So I'd like to switch it back to Malvina to take us through some more information.
Right. So you realize that you either qualify for one of these categories, or perhaps you have an approved I-140, And now you see that the visa bulletin is current for the month of April, and you can file your individual adjustment of status application for permanent residence during the month of April. How is that beneficial? How is that beneficial to you? And so it's beneficial if you are in the United States in another non-immigrant category, such as H-1B or L-1 or O-1. And this allows you to actually file your individual permanent residence application, and that for your family members, which are can be a spouse and any child under the age of 18, under the age of 21. It allows you to file your residence applications in the US. And a huge reason why that's beneficial, of course, is that it's the last step towards actually getting your green card. If you have the approved I-140, that's terrific, but that's still not the green card yet. The last application is really what gets you the green card for you and your family members, immediate family members. With the filing of the I-45 application for permanent residence, you and each of your family members can concurrently file applications for a work authorization card and travel document. The work authorization card, we often refer to as an EAD, Employment Authorization Document. The travel document we often refer to as advanced parole, or AP. And this is really beneficial in a lot of ways because under your non-immigrant status category, perhaps your spouse wasn't able to work or able to get a work authorization card. I will say L2 spouses, that is spouses of those who are in L1 status in the US, are eligible for a work authorization card, but children are not. So if you have a teenager at home who's 17 or 18, really wants that part-time job, they can't get it if you're in L1 status and the child is in L2 status. Or if you are in H-1B status, perhaps, if you are in H-1B status and you have an approved I-140 petition with a priority date that hasn't been current, right now H-4 spouses are able to get a work authorization card. But sometimes, people just haven't been able to apply for that. So the benefit of filing your adjustment of status for permanent residence in the US is really in so many ways. It gets your applications in the door. You can get the work authorization and travel documents. I will say that filing the applications all together is terrific, but you do have to know that the time period to get the work authorization and travel cards, the EAD AP card, is right now taking several months. And I would say maybe close to 7 or 8 or even 9 months. In the past year, USCIS has had tremendous problems due to the pandemic, with not as many workers being able to be at the service centers, various other administrative problems. So while you are eligible to receive this work authorization travel card, and even, this is everyone, you yourself and your family members, it does take several months to come in. So that's just something to be aware of if you file for adjustment of status in the US. Once you do have the work authorization and travel cards, if you feel that you need to no longer remain in your non-immigrant status, such as L1 or H1, H1B, you can let that non-immigrant status go and continue working in the US only on the work authorization card and travel document. It's good, though, to be careful of that. We do advise our clients to maintain your non-immigrant status if you can, because there may be delays in getting the work authorization travel card. The travel cards, EADs, are generally good for 1 year, sometimes 2 years, but if they're up for renewal and you are waiting for the new card to come in and you need to continue working or traveling and that new card is not there yet, you'll have a problem. If you do file a permanent residence and you file for the work authorization card, when it comes time to renew, upon the filing of that renewal application, your current work authorization is extended for 180 days automatically. So if the card's running out, you do get an automatic extension of 180 days. But if your travel card has expired, you won't be able to travel outside the United States. So there are some advantages to getting those cards. It's also just, you really need to be mindful of the USCIS processing and the expiration dates of those cards. Another advantage.
Sorry about that. Keep going, Malvina.
Sure, okay. So one other advantage that's very important to be aware of is if your I-140 petition is approved and your application for permanent residence has been pending for 180 days, you can actually port to a new employer. And what that means is you can leave your current employer that might have filed the I-140 petition if it was an employment-based I-140 petition, and you can move to a new employer so long as the work that you are going to be doing for the new employer is sufficiently related to what you were sponsored for in the I-140 petition. So if you are a data science researcher, for example, with an approved I-140 and your application for permanent residence has been pending 180 days, you can leave your current employer, go to a new employer, but you still need to be working in the field of data science research. You cannot completely switch fields because then the porting to a new employer won't work. What that means is eventually when it comes time for USCIS to complete the processing of your permanent residence application, if USCIS does conduct an interview, which sometimes for a time they have been conducting interviews at the local office level for employment-based applicants. They've gotten away from that for the last few months, and they may do away with it entirely. But whether they do an interview or just complete the processing, USCIS often asks for an updated letter for you to establish that you are continuing to work for either the same employer that sponsored you for the I-140 petition, or if you're working for a new employer, you're working in a role and the new employer is sponsoring you for a new role that is sufficiently related to what you were sponsored for before. So those are some of the benefits of being current. If you are abroad and are awaiting for your immigrant visa petition to move forward, because you can apply for permanent residence either in the US or you can be outside the US and apply for your immigrant visa through the US Embassy or consulate in your country. With this being current at the moment, your application could move forward. The recent presidential proclamation that former President Trump instituted last year to put a stop to the issuance of new immigrant visas abroad has been rescinded by President Biden. So that is no longer in effect. So those applications that were in process can continue to move forward again. There are, of course, still many delays at this point because of the pandemic, because of the embassies and consulates, many of them being still closed to routine visa processing, whether it's non-immigrant or immigrant visas. But it does move things forward, and it really it gets your foot in the door, whether you're applying here in the US, or at least will move your application forward a little bit more if you are applying from abroad.
Awesome. So I think we're going to move forward with a Q&A now. So anyone in the chat, the way this is going to work is please just turn your video on, pop in and ask a question. We figure that a lot of the questions you'll ask will be relevant for others. So please feel free to go ahead and do that. And if you want to write a question in the chat, that works too.
Hi, this is Ashish. Thanks a lot for holding this session. I have a couple of questions. The first question is, let's say if I do want to apply an EB-1 and I want to do it in the month of April, what are the steps in terms of the engagement steps? And number two is, let's say I've applied for for EB-1. Do I need to stay in the country until a decision has been made?
I'm going to take the first part of the question, and Malvina, you can take the second part. But on the first part, if you're working with our law firm, the first part is you want to send us a copy of your CV, and let's schedule a free complimentary conversation. Normally we charge $300 for a consultation, but if you're on this call, just remind me you're on the call, and we're not charging for a consultation to review your CV. We'd want to review your current status and understand when that's expiring, what timing is like. We'd want to know about your travel plans. And we take you through it and give you our thoughts of whether we think you're going to have a good chance at qualifying for EB-1A. If you have an employer who'd sponsor you for EB-1B or EB-1C, and we'll take you through it. We then would email you a summary of our conversation and what our advice is and what our thoughts is. We'd send you an engagement letter that spells out our fees, and we'd let you think about all this, and you can choose to hire us or not. If you hire us, given that it's only current in April right now, that's all we know about, we certainly will jump on this and make sure that if you're talking to us in the first week of April, even though normally it might take us 3-4 weeks or more maybe to put together that perfect application, we can file in April, because we can, if we have to, we'll file just slightly less than a perfect application to make sure we make it on time, so that not only your I-140 is filed in April, but so is your I-485. But let me tell you, Ashish, by April 12th through 15th, we're going to see the May visa bulletin come out. And if it turns out you're current in May as well, we'll have a back and forth about whether we're still rushing, or do we want to just do we need to take a little bit more time to make sure it's a much higher level application. We really want to avoid what's called a request for evidence if we can. And that's how we would proceed with you. But you'll have all the information about the fees and everything right from the beginning. We work on a flat fee on everything we do, and so there's no surprises about fees.
So to your second question, Ashish, whether you can remain in the U.S. to complete the process, if you're already in the U.S. in a valid non-immigrant status, you must be in the U.S. when the adjustment of status 45 applications are filed for you, and if there are any family members, they must be filed while you're here. Whether you can leave or not while that is pending depends largely on your non-immigrant status. First, you can stay until you receive the work authorization advance parole card. Once you have that card in hand, yes, you can leave the U.S. and return while that card is still valid. If you do not want to wait for that card to come in, if you are in H1 or L1 status, you can leave the U.S. After the permanent residence application has been filed, and even if you haven't received the EAD-AP card yet, you can leave the U.S. You do still have to make sure that you have a valid H1 or L1 visa in your passport before you come back. But only in those two categories can you come and go without having to wait first for the work authorization EAD-AP card. If you're in any other non-immigrant status, such as O1 or F1 or any other non-immigrant status, if you leave the US before that card is issued, your residence application, not the I-140 petition, but the individual permanent residence application, is considered to be abandoned. And you would eventually have to file it all over again after you come into the US. So it is possible, but you just have to make sure what your non-immigrant status is and really the validity of those documents before you leave the US.
I want to take it what Malvina said is 100% correct. I want to take it one step further. Some of you on the call might be in O1 status. Now, O1 does not have the same kind of dual intent as H1 and L1, and that's why Malvina said, if you are in O1 and you file your I-45, if you leave the US after filing, before you have the advance parole travel document, your I-485 will be void. And the advance parole travel document is taking about 5 months to get. So what happens if you're H, no problem. H or L, so come and go and come and go. But if you're O1, how do you solve that problem if you simply cannot wait the 5 months to get advance parole? Well, one way to solve it is to file the I-140 for the EB-1 category, but not file the advance parole, not file the I-485 adjustment of status application. If you do that, you're not abandoning anything, and you can come and go in your O1, and then you can ultimately get the green card at the US consulate in your home country, or if it turns out that your priority date is current in a future month and you have 5 months where you know you don't need to travel, you could file the I-485 at that time.
Awesome. Thanks, Ashish.
Thank you so much.
So the 2 questions came through the chat. First one was, can premium processing increase the chance of an RFE on a green card?
So I can answer that. It's a very good question. And it is sometimes possible that you will get an RFE because you have premium processed your application, because the premium processing, which requires an additional filing fee of $2,500 now, requires USCIS to respond within 15 calendar days. That's weekends and holidays included. And we have found in the past when premium processing, that unit cannot issue a response, namely an approval, within those 15 calendar days, they issue an RFE to essentially buy themselves more time. And often we can tell this when we get an RFE because they're asking for information that was already submitted with the initial filing, or they're asking for proof of the criteria where the person clearly meets the criteria, but it's kind of boilerplate. There's really no reference to evidence that was submitted, just a general explanation of what the law is and saying, you know, the evidence you submitted is not sufficient. So when we see general boilerplate emails, RFEs like that, it's generally because premium processing didn't have enough time. They issue the RFE. They know that you will need to take time to respond fully so that your application is approved. And premium processing will give you 87 days. When you submit the response, premium process, a new 15-day period kicks in again. But so we have seen instances of RFEs getting issued when premium processed applications, when I-140s have been filed using premium processing. If your case is strong, though, it shouldn't take much to respond to that fully so that you can, you know, continue the processing.
We have not seen an increase in denials simply because you used premium processing. At our firm, and I think probably true for almost all really top immigration firms, we're running at a 92 to 95% approval on all EB-1 petitions, and we're filing a lot. So we're not afraid of an RFE, and we're pretty confident of an approval if we take your case. We're the first ones to tell you this is not a good case to file. We don't want to start down that path if we don't think it's going to win. But if we file it, we're pretty sure it's going to win. We're not afraid of an RFE.
Next question that came in was, this individual has just applied for a J1 waiver, and they're wondering if they need to get the waiver approved before they can apply for a green card.
It's a very common question. You don't need to wait for the waiver to be approved to file the I-140, the first part of the green card process. You do need to have an approval of the waiver to file the I-485. Now, when you file a waiver of the J1 2-year home residency requirement, there's actually two approvals that come. The first is from the State Department, and the second is from the U.S. Immigration Service. You don't have to have both approvals in hand to file the I-485, but you do need the approval from the State Department of the waiver, and only then can you file your I-485.
Great. Another question came through the chat. This individual is an OPT now, which expires on July 2022, and is wondering if they can file an EB-1B by the end of April. If they do, would they need to get working on the visa in the near future?
So if you do file the EB-1B together with your adjustment of status application, chances are you might get the EAD AP card that allows you to work in the US by the time you reach July 2022 when your OPT expires. I would first look into whether you are eligible for a STEM OPT extension. That depends on the code on your I-20, if it's a STEM field. So you can look into that. But if you're not eligible for a STEM extension and your OPT definitely expires July 2022, you might get the card in time. If you do go that route and you rely on waiting for the EAD AP card, certainly you cannot leave the US while you're waiting for that EAD AP card. And additionally, because the F1 category, which is the basis for F1 foreign students and OPT and STEM OPT, is a strictly non-immigrant category. You cannot have immigrant intent. And of course, the filing of an I-140 and I-485 clearly shows immigrant intent. You cannot ever travel again if you have a valid F1 visa. So if you have received the EAD AP card and you want to travel internationally after that, you cannot come back to the US using your F1 visa and your passport if there is a valid F1 visa, meaning you cannot come back and continue your OPT until July 2022. You have to come back using the EAD AP card because F1 is strictly non-immigrant and you know, you really have to wait for that EAD AP card. So there is a possibility. I will say though that last October, the visa bulletin became current or moved forward dramatically for the Chinese and Indian nationals, many other categories for October and November. USCIS received a flood of adjustment of status applications during October and November. And the logistical consequence of that is USCIS took, in many cases, 2 to 3 months just to issue receipt notices. And they haven't even reached the point where they are issuing biometrics appointments, which is a fingerprint appointment in conjunction with the EAD card application. When you file the EAD application, you have to get biometrics done. It's also part of the permanent residence process. Those individuals haven't even received biometrics appointment notices, which they normally would by now. We don't know when those cards will be issued. So USCIS is still dealing with a backlog from those applications, with EB-1 for China, India, all countries becoming current in April. There could be a significant backlog as well. So I would just anticipate that it might be a while, but I think filing by end of April, I think there's a good chance you'll have your card before July of 2022.
I just want to clear up some confusion I'm having and maybe others. The scenario was, if you file in April of 2021, will you have an EAD by July of 2022? That's a year and 4 months away. I think definitely you're going to have a card by the summer of 2022. Right now, they're taking 6 months, maybe 7, maybe 8, but not a year and a half. So I think, I didn't know if you were, Malvina, you weren't referring to the summer of 2021 or 2022, but I think it's almost sure you'll have an EAD by the summer of 2022.
Right.
I have a question that's come up here to me. The question is, can you file more than one category at the same time? And the answer is yes. In fact, it's somewhat common, and the U.S. Immigration Service would not hold it against you or think twice about it, really, if you're filing at the same time in 2 different categories. Why would you do that? Well, sometimes an employer is willing to start a perm labor certification application for you in EB-2, and the employer goes ahead and is doing that, and you're quite pleased with the way things are going with that, but you also would like to try an EB-1 at the same time, and given that it's going to be current in April, you're wondering about what if you file your own EB-1, such as an EB-1A that you can file yourself. The answer is yes, you can do both, and it would not be held against you. You can only have 1 485 pending at the same time, but if you're from India or China, you really can't file an I-485 right away through an EB-2 is not current. So EB-1 is current in April, so you would file your I-485 now and get that filed. I just want to jump in with another question because it's really important. If the priority date is current in April, can it go backwards and suddenly not be current? And the answer is yes. In fact, it's rather common as well that these categories move ahead, they move back. They move ahead a lot, and then they move back a little. So you could file your I-140 and I-485 in April under an EB-1A category, only to find out that then it goes backwards in May or June or July. you're lucky because you filed when it was current, so you're entitled to the work authorization document and the travel document. And if you're married, so is your spouse. That can't be taken away from you, even if there's a retrogression. But it might be that EB-1A doesn't come current again for another year for India or China. And if that happens, you're in better shape than if you hadn't filed, because you can get the work and travel permission, but you simply can't get it approved. You can't be given the green card until it's current again.
Great. Are there any last questions from any of the participants that want to hop on video?
I have one more question. This is about priority dates. So let's say I have an EB-2 filed and priority date is say 2016, 2017. Can that priority date be carried over for another category, say EB-1?
Yeah, the answer is yes.
Okay.
If your I-140 is approved, you get to use your priority date, your place in the queue for any other category you file for. So you can file EB-1A now because it's current and because you can file on its own. But let's say there's a retrogression and now EB-1A goes backwards, but you have a priority date of 2017 from your EB-2 and you had an approved I-140 on that petition, you can use that priority date for your EB-1, and that's going to be great for you, because I don't think, I would find it hard to believe that EB-1 will retrogress before 2017. That would be quite astounding. I shouldn't say I'd be that surprised, because anything can happen, but you're in good shape if you have a priority date of 2017 and you're pursuing EB-1.
Okay, great. Thank you.
Anyone else want to hop in? I see one more question in the chat. We had a question: can my spouse's priority date from EB-2 be carried over to my EB-1?
Go ahead, Melvina, although I think we both know the same answer. But
right, it's my understanding that it cannot. You know, that
right.
Your spouse's priority date is really for your spouse. So unlike being able to use your spouse's country of birth to benefit yourself, the EB-2, the priority dates do not cross over between spouses.
Great. Awesome. Well, if anyone has any further questions, I am going to quickly write Melvina and Jeff's emails in the chat. It's melvina@gpimmigration.com and jeff@gpimmigration.com. And again, I wrote in the chat earlier that there is a link to their website, GPI. It's www.gpimmigration.com. And you can find there a list of the qualifications that Jeff was referring to earlier under EB-1 and learn a bit more there. But thank you so much for joining. Again, I am going to be sending out this recording to everyone, so you'll have this, and please share it with your networks. We really appreciate it. Take care, everyone.